All rise.
My Lord, just a couple of points before I move to the actual individual cases. There was some discussion before lunch about the situation relating to the rules on accommodation. Our submissions on this are dealt with in our printed case at paragraphs 99, that's on page 42, and page 43. I don't want to recite them, but I simply want to draw attention to 2 points that are there mentioned. One is the point in paragraph 100 about this case of AB, third-party provision of accommodation. And that is referred to, that is present in volume 6 at tab 55. And you'll see how, notwithstanding the President's attempt in 2 or 3 cases before this to try to root out third-party support from the maintenance provision, the Deputy President, Mr. Ockleton, and others sought to maintain it, certainly in relation to accommodation. And at paragraph 8 to 10, particularly 9 to 10, they mention some of the considerations that will be relevant. Say 9, access to accommodation in the UK is a well-known and expensive matter. Families with members who are entirely British citizens frequently find it necessary for adult children to continue to live at home until they can afford to live somewhere by themselves. Part of the common experience of mankind that children, even adult children, continue to live with their parents and sometimes other relatives. In one sense, as was pointed out in argument, it might make a nonsense of the rules to say that for the day-to-day maintenance, which may well be relatively inexpensive, the parties should provide their own funds, whereas for most expensive part of their lives, that is to say their rent and other accommodation, they're entitled to rely on the beneficence of others. Another way of looking at that is to recognize that because accommodation is so expensive as an element in living costs, reasonable to expect the parties to pay for the rest of the living costs themselves and perhaps rely on usual traditions and practices for housing. But they concluded, or then over the page, paragraph 12, what it is that is required. It seems to us that what the rules require is totally as follows. 12 and 13, if perhaps those could be just looked over.
So he follows the party line as it were in paragraph 12,
yeah.
But really, looking at practical reality, you can't accept that in paragraph 13.
That's right. And we say the approach in paragraph 13 really ought to end up subverting the party line, if I can use that phrase. And the other case I wanted to draw attention to, because there was some discussion about occupying exclusively before lunch, is in the same bundle at tab 60. And it's, again, Mr. Ockleton, again a decision that I commend to the court. Again, and the rubric at the top perhaps sums it up. The requirement in the immigration rules that a person own or occupy exclusively property does not carry any technical legal meaning of exclusive occupation, sufficient if there's a defined place where the person lives, which he has as his home, with the implication of stability that implies. Essence is stability, which is focusing on reliability. But the whole of the judgment, the whole of this decision is in fact quite instructive, and particularly page 4, which I, paragraphs 7 to 9, which I invite the court to accept. This is the approach that's been applied in the tribunal.
So that, which is first of those two?
Yes, it's tab 60 is before tab 55.
Does he refer to
55 came after, did he?
55 came after 60? And did it refer to it?
I'm not sure.
No, yes. KJ is referred to paragraph 8. I'm sorry.
The point for my purposes is that both of these decisions are in fact after, as it were, the President's line had been developed in cases like AA Bangladesh.
Oh yes,
and,
exactly.
Yeah.
Yes, that's why paragraph 12 is worded as it is.
That's right. Yeah. And KJ is also after that line began to develop.
But David, you say that
Yes, just to be clear, KJ is referred to in AB in paragraph 8. The last sentence.
A, B, sorry, paragraph. Yeah, I got it. Thank you very much. Thank you.
The argument, I think, there,
Yes,
but it,
so it is.
It was referred to in argument.
So it is. But insofar as the court may make comments in relation to the accommodation, then those two cases in particular are worth considering. And we end up our submissions on this in our printed case on page 43 at para 102 by saying it's difficult to see how, or Justice Laws can take the view that the Secretary of State that the Secretary intended that third-party support was forbidden throughout the rules on maintenance, yet accommodation from third parties was allowed. As I read the respondent's case, they say there should be no difference between the two. And yet the respondent at no stage has sought to say or do anything in relation to the rules relating to accommodation, but for the assertion now made in the respondent's case that accommodation should also be treated in the same way. That, I think, is all that I certainly in opening submissions I want to say about the central point. In paragraph 105 of our submission of our printed case, certain examples of absurdity are mentioned. There are going to be issues arising out of this which have an impact upon the Article 14 type arguments. Those are arguments that Mr. Fordham will deal with. What sort of disparities this can lead to and so on. What sort of discrimination situations. But those are matters which we are not developing because the government cases being brought up also relies on what is important. Moving then to the actual individual cases themselves. If I can deal with the case of PS first. In the S's case, the issue purely and simply was third-party support, and you'll see in the VS core bundle how Lord Justice Sedley put it when he was granting permission at page 41 of the VS core bundle, page 41, item 3.
sorry, for the appendix is this?
Yes, appendix.
Yeah.
In VS, page 41. Lord Justice Sedley's grant of permission, limited to the argument under the rules.
Which paragraph are you asking?
Paragraph 2. What he said was this. It's the conflict point that I've already referred to. And that you've already
Is it usual these days to give a judgment like this when you give leave?
Yes, short, but Yes.
Will you give leave? Yeah.
Yes. On an oral hearing, yes. Paragraph 3. The immigration judge found that it was in these circumstances Mr. Aranoon, not one sponsor of the intelligence defender, the lordship to recall the facts that Mr. Aranoon was provided funds.
I think reading between the lines, looking at paragraph 10, he was concerned that there were a lot of other cases raising similar points. This is not helpful to set out his reasoning.
Yes. Well, it is very helpful, but I didn't know they did it.
But in paragraph 3, this point about conduit, which we've already discussed, is the point that he's making. Senior Immigration Judge Baptist ordered reconsideration because he thought a different decision on this point was a real possibility. It was clear from the earlier decision the Home Office, as I've said, was disinclined to try to sustain the immigration judge's reading of the rule. The AIT's decision, despite this, to uphold the immigration judge is found on the AIT decision, AA Bangladesh, which is, as we've said, the first one after the Ahmed Ali case, which is said to establish that third-party support is not permitted, and is based on the earlier AIT decision, MK Somalia, which of course was overturned in the Court of Appeal. That decision, however, which was to the effect that funds from sponsored sale living allowance did not count as recently been overset by this court, etc. The present case is not foursquare with MK Somalia, but without disrespect to the refusal on paper, it does seem to me that there's a respectable argument that one cannot properly differentiate between the sources of the sponsors' available funds. He might legitimately have made it his case that the money he sent his father was his, and it was Mr. Aranoon's generosity in paying him £100 a month that enabled him to send it. It was because instead, both he and Mr. Aranoon treated the letters and funds specifically earmarked for the account, in all in reality, of course, a fictional earmarking, that he was bound to be a mere convict of Mr. Aranoon's money. And one appreciates the reset the line in such a position leads to a different anomaly by requiring this application of Rule 317, where the benefactor provides the account with funds directly rather than through the sponsor. For present, that may not matter, and it refers to MW Liberia. The point that he's making is the point that I sought to make earlier this morning. This is simply was in the decisions of the immigration judge and the AIT, a labelling of the arrangement as a conduit without actually placing any correct analysis upon the actual substance of the arrangement. It is that finding by the immigration judge, that labelling by the immigration judge, which led Lord Justice Carnwath then to say in his judgment in the Court of Appeal, because of that finding, VS's case must fail. But the question is not because of that finding, VS's judgment should fail. The question really is, what does that finding mean? What are the actual facts that it is trying to describe? The facts that it is trying to describe are a perfectly normal arrangement of a family friend giving Mr. Aranoon, giving money, wholly reliable, wholly credible, completely accepted, to the sponsor, whose money it is to do with as he chooses, but they both know it's going to be used to support, and is going to be used to support the father. As regards the immigration judge's own decision, on the same appendix, at page 51, the immigration judge's decision. And this also ties in with the points about precariousness and reliability of third-party support, because here you see at page 58, immigration Judge Mayall's decision, page 58, paragraph 59, it seems to assess the evidence. Subject to cross-examination.
Page 59.
Page 58, paragraph 59 as well.
Yeah.
It means to assess the evidence there. Fully accepts the credibility. Paragraph 62, I also saw and heard Mr. Aranoon give his evidence. Again, he struck me as being entirely credible and honest witness. Again, I accept his evidence. So the reliability of this third-party arrangement was fully accepted, tested and fully accepted. In paragraph 63, he says, I accept the appellant receipt of government pension in Sri Lanka, which is worth about £80 a month. I consider the expenditure of the appellant in the UK to be modest. I accept that the combination of government pension, the money from Mr. Aaron, and in such small amounts as the appellant may be able to save from his own benefit, would mean that the appellant would be going to be able to maintain the right to public funds. I take note of the fact that the appellant passport in July market has cogent evidence to suggest the passport will continue. In this case, I am satisfied, having heard the evidence of the concept, because that third party sport will continue. So the 3174A question is completely satisfied on those facts, looking to the future. Then at 64, there remains one requirement of the rules that I must consider, and that is 3173, should be going to be And then he considers the facts in relation to that, and says at 66, I'm satisfied the appellant is wholly dependent on that money. Without it, he could not survive. 3173 question is wholly resolved in our favour. The only question, 67, the only question is whether in these circumstances it can be said that the appellant is dependent on the relative present and settled in the UK. And on that, because of the previous cases, he says, well, that is not a dependency upon the sponsor, that is a dependency upon the third party. And the 69A Bangladesh 2005 case, 670 mere conduit. Because of that final statement of principle that you can't have that third party support, the case is ruled out. And with some regret, in paragraph 72, he finds that he's not satisfied with the rules. And Article 8, he discusses it, and again with some reluctance to the bottom of paragraph 75. Regret again mentioned it's paragraph 76. So one asks whether such a reading of the rules really is necessary so as to rule out third-party support when everybody recognises, having fully tested, that this Mr. Aruna is as bad as genuine and as perfect a provider of third-party support as you could get. That cannot be the purpose of the rule, to rule out such providers.
Well, if the submission you advanced this morning is correct, he misdirected himself on the proper meaning of little 4A in the rule. What do you ask us to do then?
I ask you to say that upon the proper application of the test, that if the test had been properly applied, on those findings, it must follow that the appeal should have been allowed.
Sorry, I was just looking at what Lord Justice Carnwath said about all this, because of course he was with you on the point, and I'm just looking how he dealt with the two cases where the point was material, your case VS and also MIKA, which he deals with as well. Does he say that the appeal would have to be allowed without more, or does he say that there are further issues that would then, he says remit for redetermination, doesn't he, or am I wrong about this? No, wait a minute.
No. What he's saying is paragraph 109.
Paragraph 109,
Yes.
that's right, he,
Ended up at 113.
two separate questions. First, well, which case is he on there?
Well, KA.
You know, he's by that stage he's at KA. Where does he deal with the? Oh, here we are.
109.
109. Okay, not.
As a finding of fact, this seems to be unimpeachable, and to conclude the case against the appellant.
Oh, so you lose.
Right.
So wait a minute. So you appear to have, even though he's with you on the construction of 317, you lose VS on some. What's the basis on which you lose it?
Well, the basis is that the thinking on mere conflicts which bind this division of the Court of Appeal carries over, nevertheless, into the consideration of the facts of VS in the context of 317. And
Does he not? He doesn't really get that far, does he? Because he stops at little 3.
3173.
That requires you to be financially wholly or mainly dependent on the relative.
That's-
That's not so.
yeah, yes, I'm sorry, yes, that's right. And his reason for saying that is that because the immigration judge said that Mr. Aruna, who actually provided the money, was a mere conduit, he says, as a finding of fact, that is unimpeachable. And that concludes the case again. That's his reason.
That's the paragraph 67, which shows us the judgment.
But we say this misunderstands the nature of the arrangement. To call it a mere conduit is to diminish its importance. It is not what one labels it, that is, a conduit or anything else. It's whether the arrangement in question is an arrangement which is capable of satisfying the rule. Ultimately, this point by Lord Justice Khadra goes back to the very same point. Is support from a third party permissible? If support from a third party is permissible, it's going to come through some conduit or other.
Are you saying that 3173 and 3174A really necessarily admitted the same answer?
They may not necessarily admit the same answer, but the point about a conduit under 317 is the point that I want to get across. What the immigration judge said is that because the money is coming from Mr. Arunan, the sponsor is simply a conduit. Therefore, that means the appellant is not dependent on the sponsor, but is actually dependent upon Mr. Arunan. We say that is actually the very fundamental question, which is the question of principle. Is third-party support from a third party permissible?
Well, you could say, Mr. Gilbert, I'm just thinking about the moment that little 3 actually doesn't raise the issue about third-party support. It's looking at the relationship between the person who's seeking entry and the relative who's present and settled in the United Kingdom. Is that relationship, is he wholly dependent on that relative? Raise the issue as to whether he can be maintained for little 4A.
Well, that is right, but what 373 is saying is financially wholly or mainly dependent on the relative settled in the UK. To say in dealing with that question that you're not wholly or mainly dependent upon the relative currently because the money is coming from a third party is actually to rule not on a question of fact as such, but to actually, first of all, to decide the point of principle against you. And that is to say, such third-party support is not actually permissible. So this statement that he is a mere that the sponsor is a mere conduit is a statement which really is from the immigration judge's point of view, is really no different to saying that, in fact, third-party support from a third party is simply not permitted. Because it's not permitted, he's a conduit. Because he's a conduit, therefore, the appellant is not dependent on the conduit, but is dependent upon the provider of funds. It's really the same question.
Dependent at what time? Dependent when?
It says...
It says is financially.
Is.
That's at the time of the application.
That's right.
It's the same as 2. Whereas
Yeah.
the first bits are all in the present tense.
Yes.
And 4 and 4a are forward.
But must one not focus on what is meant by financially or mainly dependent? As my Lord Hope points out, if the emphasis is on the dependence rather than the source of support, if you can put it that way, then the answer is easy. If, on the other hand, financially dependent connotes not only that you're dependent upon him, but that the finance is provided by the relative, one can conceive of a contrary argument.
If it's the latter situation, the last mentioned situation that we're dealing with, that actually does beg the very question that we've been debating this morning. And that's really why I'm saying that if the question that has been debated this morning is a question that were to be resolved in our favour, it simply to say that as at the time of the application, the son is a mere conduit, simply to say that.
Well, I see the force of that. I mean, my difficulty, I have to say, with 3 is that reading 3 could make one wonder whether, if one had tentatively thought you might be right on 4A, you properly can be. In other words, it could affect one's view of 4A.
Yes, but I'm trying to take the point on 3173 at its highest against me, and putting the point putting forward the submission that I'm making on the assumption that under 3173 an issue of third-party support is a material consideration. But on one view, if one just looks at the words of 3173, where it says, is financially wholly or mainly dependent on the relative, those words do not say anything about the source of the funds at all.
It's completely consistent with the normal usage of language to say that the father is financially dependent on the son, even though Mr. Arunan is paying £100 to the son to support the father.
Yes, and on that interpretation, which is the interpretation for which we contend, simply then to go on to say that the son is a mere conduit isn't really focusing on the right question. And it's misunderstanding the issue under 3173. This passage, para 109 of the Court of Appeals judgment and para 67 of the immigration judges, this language of conduits is simply rooted in an approach which itself, in the previous cases, is an approach which is contrary to the correct construction of 3173.
Supposing you have two situations. Supposing Mr. Arunan said to the son, well, I know you've got a father whom you would like to support, and to assist you, I'll give you every month £100. You could do it, right, but I hope that will enable you to support your father. That's one thing. Another situation where Mr. Arunan says, if you come round every Friday or every month and pick up an envelope and pop it in the post, and to send it to your father. And all you need to do is to pop it in the post. Are these exactly the same situations? Is the first one might be dependent, no different than the second one at all, and analytically no different?
My Lord, the second situation, whereby Mr. Arunan is presumably putting a check in made payable to the father, and it is going in an envelope, may show that that situation, depending upon what the rest of the evidence shows, is a situation which establishes a much closer connection between Mr. Arunan and the appellant. But in substance, if it is the case that the sponsor is saying, look, the reason why I'm going around there to pick up the envelope, or the reason, and the reason why Mr. Arunan is going to give it to me, or the reason why Mr. Arunan just gives me money as and when. The reason for this is that in both cases the same, and the reason is that he wants to assist me in order to do what I have to do, is to discharge my responsibility to my father, to maintain my father. In that scenario, the situation is, there's no difference. And it's the latter scenario which in essence is what the evidence before the immigration judge showed. That's what Lord Justice Sedley was saying. Simply because one is earmarking this for the sponsor doesn't really get you very far. In essence, it's the same thing.
But Mr. Gill, I don't know, I mean, I don't like it, but one of the problems may be this, you see, I mean, just assume Mr. Arunan wasn't just a friend, but was indeed a close relative.
Yeah.
But just assume instead of being in England, in fact, giving the money from England, he was giving it from the same country as Grandpa was in. He's then shut out by 3175 in terms, isn't he?
Yes.
Well, doesn't that begin to cast a little illumination possibly on the overall scheme of this provision? I mean, it's a sort of precondition that you actually have to be with this relative you're joining, or there's a particularly good reason to be allowed to join him because you're financially dependent on him and there's nobody else you can turn to.
It's certainly it is focusing upon a dependency between the sponsor and the appellant. But how the sponsor chooses to or is able to discharge the dependency is not actually addressed there. In the example your Lordship puts forward, that a relative in his own country, with that example, there are particular reasons why the rule as a whole shuts out that sort of example, because what it's really saying is that if you can actually, if there are close relatives, not just any relatives, but close relatives, people who you would ordinarily be expected to live with, be dependent on, with whom the relationship of that closeness can be expected to appertain. With those sort of close relatives, if you've got those sort of close relatives in your country, you should really be turning to them. But if it's some distant relative with whom you're not really expected to live at all, to whom you're really not expected to turn at all, could be a relative in a third country who has got the money, who relative in a third country who provides but not a close relative at all, who provides the money to the sponsor in the United Kingdom. Sponsor is then able to discharge the obligation to support the appellant. So 3175 doesn't really throw any light at all on 3173 or 4A.
Well, I just wonder whether it doesn't, perhaps in your favour, by saying that in this particular case, it could not be saying that he's turning to Mr. Aruna. To whom is he turning? He's turning to his son.
Yes.
Now, his son's financial capacity is funded by Mr. Arunan, but as Lord Hope has pointed out already, the emphasis in 3173 is on the dependence. Financial dependence, yes. Doesn't necessarily speak to the capacity of the relative or the son to discharge his responsibility.
We're told how this arrangement came up. I'm looking at paragraph 65 at page 59. We're just told that that was the arrangement. Although the judge is rather careful to say that he's entirely satisfied that the money was here.
Paragraph 30.
That's fiction, because in fact the money was earmarked, so it wasn't.
Well, paragraphs 37 to 39, I hope answers your Lordship's question as to how this arrangement came up.
Which ones?
37 to
39,
I see.
page 55.
tell us the I see, long-term friend. The question is that he's a very generous man and would be willing to help anybody, really.
Well, no doubt, but he is providing those funds. He's providing them on the basis of a sense of loyalty to the sponsor. The sponsor is the one upon whom the father is dependent, and who is discharging that dependency. And this arrangement comes about in a way where the money is not. To say the money is earmarked, set aside, separated off in such a way as to divorce the role of the sponsor is not really the right way of looking at what is set out at 37 to 39.
Well, so why do you say that's not? I mean, that's the finding. I mean, that's the way the judge who heard the evidence, that's what he found. I mean, how can we say that's not the right way of putting it?
Because the evidence is...
That's a summary, but this is what he said, he's entirely satisfied and so on. It's difficult for us to go behind the finding of fact, as he puts it.
My Lord, where this statement is simply lifted from the previous cases which talk about conduits in the context of third-party support, well, where a statement is made is simply in terms of conduit, there must be a worry that, in fact, at the very least, that the factual arrangement has been unreasonably described. It is not really a conduit as such. All that is, and even if it were a conduit, what do we mean by a conduit in this context? it's not some passive, irrelevant actor. It is somebody who has a role to play. And there's nothing in these findings which suggests that the son does not have a role to play. He does. And that being the case, it's a bit artificial then to say, just because it was then labeled as a conduit, somehow the reality of that arrangement has to be brushed to one side because the court has difficulty in oversetting a finding of fact which describes it as a conduit. The reality of it is something else.
Well, there it is. That was a crucial point in the case. And as I said earlier, he didn't get to 4A. He resolved the case on level 3. You say that that's wrong. If we're in your favour on the point you just made about the conduit argument, you say, well, we should simply allow the appeal. But is there a point still to be considered under 4A? Could it not be said that it ought to go back to the tribunal?
Well,
in the light of the fact that if you're right, they shouldn't have stopped at 3.
well, at paragraph 63, the immigration judge's findings appear to dispose of that question in our favour.
Sorry, which one?
63.
Paragraph 63 on page 58.
The third party support will continue.
Yes.
Yeah.
So,
And also that his requirements would be modest in the United Kingdom.
he's addressing the 4A
Could be
question.
maintained without recourse to public funds.
Yes. So it's the one requirement. So he solved everything else. Paragraph 64 is really saying all the other tests are satisfied, but I'm troubled by it.
Yeah.
Yes.
That's right. Yeah. And it's simply this labelling of conduit. That's the problem. And I understand the court's concerns about having to go behind a finding of fact. But when the finding of fact is simply a label to describe a set of undisputed facts, the court can look at those facts in paragraphs 37, 39 in particular, but up to cross-examination as well, 43. Those are the facts. And on those facts, 3173, we say, was quite clearly satisfied. Well, that's the VS case.
So we go back to AM, which is a 281.
That's right. That's right. And in relation to AM, if the point was of principle is resolved in our favour, the appeal on the findings, we say, had to succeed. The immigration judge's decision is in the appendix at page 115, and the tribunal's decision is at page 92. The immigration judge
Is it 115, did you say?
115 for immigration judge Gibbs' decision. He, in fact, allowed the appeal under the rules of the first appellant. The second appellant, who was the son, his appeal was dismissed, and that's not before you. And he says at page 120, paragraph 20, why it is that there is satisfaction of the rule. There is third-party support here from a daughter who earned about 50,000 working for the Qualifications and Curriculum Authority. He says that the end of paragraph 20, given that the first development will be accommodated with his wife, no additional expenditures result. The additional expenses involved will be extra food, clothing, and the additional equipment or furniture, any medical treatment that you might require does not count as public funds. So the money is daughter, nephew, mother is using that money to send to the father, and that arrangement will continue. So he, what is in paragraphs 20 and 21 is then attracts the conclusion at paragraph 26, appeal is allowed under the rules. The only reason then that the appeal failed, the Secretary of State's application for reconsideration was successful, is that the tribunal, Mr. Justice Hodge, at page 92, then decided that third-party support is not permitted, and said the appeal ought to be allowed. And this is after AA Bangladesh in 2005, the next sort of main case in the President's case law on this.
You see this at page 108, in the summary. That's the key point.
Yeah.
And the little one, the third party support's not needed because paragraph.
Yes. And because of that, the appeal then failed on that key point. And he explains all of this by in a long analysis, which you'll see at paragraph 9. He says, for he, the immigration judge, took the view that the correct approach is to look at the resources of the family as a whole. This was the way the application was originally put forward. It's also the reality of how the family have been supporting the first appellant in Ethiopia. But it's that approach, recited by Mr. Justice Hodge in paragraph 9 of the immigration judge, which Mr. Justice Hodge found to be objectionable. And then from paragraph 10, there's a long analysis of the previous cases. Amal Ali is particularly analysed at paragraph 23 onwards, and at paragraph 24. So in our view, Amal Ali should no longer be followed, no longer be relied upon to support the proposition third-party support is permitted to achieve if the underlying purpose of avoiding recourse to public funds is achieved. And at the bottom, he recognises a number of other decisions to the contrary and so on, but say as well, if the tribunals have been adopting this approach, all those are old cases. And then continues the analysis and essentially concludes with paragraph 33 up to paragraph 33, the point that is then summarised in 57.1. Third-party support is not permitted under para 281, and Amal Ali should no longer be followed. Now, if that point of principle is wrongly decided, then on the evidence that there was and accepted by the immigration judge, the appeal had to succeed. So far as the facts themselves are concerned, those are amply set out in the immigration judge's decision. In particular, from paragraphs 11 to 14. We're under the heading of the evidence before the submissions are looked at.
Yes, particularly paragraph 12.
Yes.
It's really something quite substantial to rely on if it's admissible.
That's right. That's right.
Paragraph 12, it's on page 118. This is in the judges.
Yes, I see.
Summary of the facts. And Fatuna is a well-paid employment and a substantial salary.
Yeah.
Sorry, I haven't looked at this, but was there some, when the appeal, did they say there had been a mistake as to the disability allowance? Because it wasn't still being paid at the time of the decision or something. I was looking at paragraph 26 of the tribunal's decision. Maybe I misunderstood.
Well, the tribunal appeared to have thought that the judge erred in taking into account disability living allowance, possibly by reference to the fact that she wasn't receiving it as at the date of decision, but was receiving it as the date of hearing. When this matter then went up to the Court of Appeal, the appeal, although on the point of principle we failed, the appeal was remitted back to the tribunal, and the tribunal, having considered whether DLA would be adequate or not, in fact, considered questions relating to DLA, if I can put it that way. I know this is making a different point as the date at which the DLA was being received. But it seems as if when the matter was remitted back by the Court of Appeal to the tribunal in fact considered whether DLA would be sufficient on its own to enable mother to support the appellant, and concluded that it wouldn't be. This question of whether DLA could be taken into account at all.
I'd like to follow this point, because at page 99 we see the discussion in the tribunal. And I understand it correctly, but they say it was an error of law by the immigration tribunal to take it into account.
Yes.
DLA is paid to support a disabled person, and one oughtn't to assume that what is paid for one person with disability is divided between somebody else.
Yes.
It's really the benefits are designed to be adequate maintenance
Yes.
to the person who's disabled. So where are you saying we go from there?
Well, the Court of Appeal, following its decision in MK Somalia, in which it had been held that DLA could be taken into account in that part, insofar as the disability living allowance wasn't only needed or used for the recipient's needs, some of it could be used in order that the arriving immigrant could be supported and indirectly look after the recipient of the DLA. The Court of Appeal, relying upon its previous decision in MK Somalia, remitted the case back to the AIT for consideration of whether the DLA would in fact be sufficient on its own in order to support.
I'm not at all sure I'm following this. As I understood it, what the tribunal, the appeal the tribunal was saying was that she wasn't any longer receiving DLA, and all she was getting was income support. And then they go on to say, since income support is the minimum which is required to support one person, then they say you can't, you couldn't then hold that it was going to be enough to support two. Now, that seems to suggest that they at least were proceeding on the basis that she wasn't receiving DLA any longer. Now, is that not right? And
That's not right, is it? I'm told that isn't right, and there was some.
it may be easier to get this cleared up at some other stage once you've looked at it.
It certainly looks from paragraph 99 on page 28 in the Court of Appeals judgment that they thought there was still something to be considered about the sufficiency of the DLA.
That's right.
Well, they remitted that then to tribunal, and the tribunal in fact said it wasn't enough. So
That's right. It wasn't that she was no longer receiving it. That she was receiving it, wasn't it? Yeah, she was continuing to receive it. I don't think there's any disagreement between.
It looks as though there might just be a
Paragraph 67 of the Court of Appeal judgment records a concession by the Secretary of State that the tribunal was wrong to exclude the sponsors or the parents' DLA.
Yeah, I've just said that. Well, Lord, confusing though it may be, I believe what I've said is in fact accurate.
fair enough. Absolutely. It is slightly confusing. Well, maybe somebody can work it out.
But what it comes to is the DLA, which she was continuing to receive, was held not to be enough on its own. And so we're thrown back onto the question of whether the third-party support coming from the daughter is...
But is there any contest if you win on the primary issue construction of Rule 81, you then win in the light of all the findings, or is the suggestion that it's got to be remitted for further findings?
Well, I
don't believe there is a contest, Mayor.
no, there isn't a contest.
Sorry, I didn't catch that. You say?
I say no contest.
No
Mayor.
contest. So there it is. So if you win, you win. If you lose, you lose.
Yes. The amount of the daughter's income is really very substantial,
Yeah.
isn't it? So I can't see that there isn't really an issue about sufficiency.
And certainly all the findings show that it's entirely reliable and so on. So not just sufficiency, but reliability, etc. If we were to lose on the point of construction, then there would have to be a resort to the freestanding Article 8 argument.
Yes.
And in relation to that, we say that the tribunal, AIT, the decision at page 92, that decision was wrong in law, and the Court of Appeal should have so held. The points that particularly concern us in relation to that are that the Court of or the tribunal seem to have misdirected themselves in relation to the test of proportionality by still focusing upon the quote, very small minority of cases point as a test in itself. This is at paragraph 46 and at paragraph 56 of Mr. Justice Hodges' decision. Having got into article...
Page 46?
I'm sorry, page 103 of the appendix,
Yeah.
paragraph 46.
Yeah.
Page 103, paragraph 46.
Yeah.
He turns to the issue of proportionality, and he says, we do not consider it necessary to reconvene the parties to address us on the Huang decision which had come out, because the appellant committee explained that it's still expected that only a very small minority of cases would succeed under Article 8. That was the position before, albeit that the result was achieved through the concept of exceptionality, as explained by the Court of Appeal in Huang. And he goes on to say in 47, the Appellate Committee has delivered its opinion. In effect, this is because it was always the case that immigration judges were guided to the effect that decisions taken pursuant to the lawful operation of immigration control will be proportionate in all save a small minority of cases. It is not the case in our judgment that applicants will find it easier to succeed under Article 8 than was previously the case. And he goes on to, well, the rest of the paragraph can be read for itself, but this, we say, is fundamentally to misunderstand what the House of Lords was saying in Huang for reasons that I'll explain in a moment. He makes the same point in paragraph 56, as having carefully considered, at the bottom page 107, all of the competing considerations in this case, in the exercise of a judicial task, we have answered the ultimate question in favour of the decision being upheld on Article 8 against the appellant. Well, yes. We find that this is not one of the very small minority of cases which, although it is not covered by the rules and supplementary directions, is entitled to succeed under Article 8. He directs himself by reference to looking to see whether this case falls within the small minority of cases or not. That's not the approach that should be taken. That will be the result of a properly structured approach. That will be the consequence, the effect of a properly structured approach to proportionality. It is not the guiding principle. And yet 46, 47, and paragraph 56 all suggest that it'll be business as usual and that really nothing has changed post Huang House of Lords. Our arguments on this...
Well, I'm not sure if it's a fair criticism. I mean, if you look at paragraph 47, I mean, what he says in terms is, on the second page, 104, immigration judges, when assessing it, got to be careful to state clear their task is, etc., etc., etc. Then they answer the proportionality question by stating whether they find the case they're dealing with, although not covered by the rules, is entitled to succeed. And then they simply talk correctly in terms of the expectation. I mean, they're not saying, when you do weigh up all the competing considerations and give due weight, etc., etc., bear in mind that it's only exceptionally, or only in a very small minority of cases, that it will be appropriate to find that they weigh in favour of the applicant.
Well, my lord, the first thing he says in paragraph 46 is to focus upon, when he's directing himself to the relevant test in Huang, to direct himself to the very thing that he shouldn't, which is to start off with the point that only a very small minority of cases would succeed. He then goes on to compound it by simply by saying at the bottom, whilst I don't dispute what your lordship just said, he says at the bottom, it's not the case that applicants will find it easier to succeed than was previously the case. Well, clearly, it must be the case that applicants will find it easier to succeed. After all, why were Huang and Kashmiri, the two cases, remitted back by the House of Lords for rehearing if nothing was going to change? The reason is because the difference in approach between the Court of Appeal's approach in Huang and the House of Lords' approach in Huang was that there was a question to be answered upon remittal of Huang and Kashmiri. And there was a difference. There was something which was going to be slightly easier to satisfy. The reason being because the test which was previously being applied, which is one of exceptionality, so that one is looking to see, is this one of the small minority of cases? That isn't the approach to be adopted. The approach to be adopted is proportionality. The best way of understanding this is to look at AG Eritrea, where the error is actually fundamentally and very clearly.
Are you coming to Huang? Because if you look at volume 3, tab 24, Huang is set out. Paragraph 20 is the source from which the idea comes. And Lord Bingham was very careful at the end to say that, echoing the words that were echoed actually by the AIT, that the small minority point is the expectation. But that's not the legal test. He sets out what the legal test is.
Absolutely.
Now, the fact that that word is picked up by the AIT suggests to me that they knew quite well what the legal test was. And they're just relating this fits in within that separation.
Well, my lord, this is the problem, because if one picks up on those words and focuses on those words, the danger is that your mindset is going to be to focus upon, is this one of the small minority cases? That's not you shouldn't be thinking about whether it falls into the small minority of cases. What you should be thinking about is, upon a proper application of the test of proportionality, what is going to be the result? The result may well be that those cases which succeed will be one of a small minority of cases. The explanation for this is in AG Eritrea. AG Eritrea is in volume 4 at tab 29. Tab 29. And despite the tendency of tribunals and judges to still keep falling back into the trap which was identified in Huang of looking at is this an exceptional case, is this a small minority of case, this judgment makes clear in paragraph 20 what the approach has to be. At paragraph 20, Lord Bingham's proposition was set out. So Lord Justice Sedley there quotes from Huang, what we've just looked at. And then paragraph 21 he says, it was the final sentence of this passage which led the Court of Appeal in Huang Court of Appeal to ask, where does the approach taken by the Lordship's House in Razgar leave the position? And to answer at 59, the true position in our judgment is that the legislation requires the adjudicator to allow an appeal against removal and deportation for an article if but only if he concludes that the case is so exceptional in its particular facts that the imperative of proportionality demands an outcome in the appellant's favour. While therefore exceptionality featured in Razgar only as a probable consequence of the evaluation of proportionality under Article 8, and while this court in Huang sought to do no more than paraphrase Razgar, Lord Justice Lawes's paragraph 22, my lord, Lord Justice Lawes's formulation and subsequent decisions of this court in cases such as Krasniki led decision makers to treat exceptionality as a threshold requirement. In other words, this is a very small minority of cases. That's not the threshold requirement. It became apparent, too, that some were linking this to Lord Bingham's second proposition, that the interference must be of sufficient gravity. The decision of the AIT in the present case affords a sufficient illustration of what was happening, what has constantly been going wrong. They wrote, the Article 8 finding is unsafe for one or two reasons. The adjudicator used the wrong test to apply too low, however that was expressed. It cannot be said if he did look at Article 8 in an appropriate manner that there is anything about this appellant's account at all to engage Article 8. It's always been difficult to establish his private life which will engage Article 8. And nothing about this young man's private life in the UK does so. We were satisfied that it was perverse to find that on the evidence for him, this is a truly exceptional case. There's nothing about the evidence recorded by the adjudicator that could possibly be described as truly exceptional. For those reasons, error of law with Article 8 finds. When Huang reached their Lordship's house, it was resolved in a single opinion delivered by Lord Bingham. Their Lordships did not criticise this court's characterisation of key issues revolving around proportionality. Therefore, under Article 8.2, in paragraph 19, they considered the proper approach to the question of proportionality. And then in paragraph 20, and then again, the last line of paragraph 20 there is set out. But if one reads from the middle of that paragraph 20, where it says...
Well, just read in paragraph 25, and that's all that this case stands for.
That's right. While its practical effect is likely to be removal is only exceptionally found to be disproportionate, it sets no formal threshold of exception. It raises no hurdles beyond those in the article itself. It goes on then at paragraph 31 to show, middle of para 31, no doubt, the fact that in the great majority of cases, the demands of immigration code are likely to make removal proportionate, so compatible with Article 8, is a consequence, not a precondition. So when, no doubt in this sense, successful Article 8 claims will be the exception rather than the rule, but to treat exceptionality, or whether is it very small minority cases, as the yardstick is to confuse cause with effect. That's not the question that should be being asked. And the same point was then made in relation to the phrase very small minority of cases in RO India, which is at tab, volume 5, tab 49. You'll see at paragraph 11 in judgment agreed to by Lord Collins at paragraph 30. At paragraph 11, Lord Justice said, I agree, and simply add a word in support of my Lord's observations. Counsel has sought an argument today to add to the grounds on which due consideration of the order, albeit on untenable grounds, succeeded. A submission that I.J. Graham failed to apply a small minority test in applying Article. This argument, which resurfaces periodically, is a false extrapolation from the decision of the House of Lords in Huang, which made it clear there's no test of exceptionality under Article 8. Question in each case is whether removal, deportation, or exclusion is proportionate. In cases such as AG Eritrea, this court has expressed the expectation that it will only be in a minority of cases that the application of the law and rules will be held to be disproportionate. It's been regarded by Ms. Ali, and if I may say so, by other counsel, to elevate this expectation to a test almost indistinguishable from an exceptionality test. That should cease. And again at paragraph 13, I also agree, it's plain from reading of paragraph 20 of the decision in Huang, that reference to a small minority of claims is not a legal test. This is absolutely clear from the final sentence. So,
Suggest, in light of all that, it is a legal test. The question really, as the opinion was saying, is whether the breach, or the prejudice rather, to the family life is sufficiently serious.
Yeah.
That's his way, but sufficiently serious to amount to a breach of the fundamental right.
Yeah,
where do the facts stand on that?
well, the first point is that in focusing upon this idea of very small minority of cases and having one's thinking driven from the reverse end by referring to that phrase in 46 and 56, the tribunal fell into exactly the same error, reintroducing the exceptionality threshold through the back door without thinking about it. And so far as the facts are concerned, the facts show that this was about as compelling a case as you could possibly get in Article 8 terms.
The tribunal dealt with this, didn't they? Paragraph 50, well, several paragraphs, but 55 is probably where we get it best, isn't it? Page 107.
Well,
you quarrel with it, of course, but I can't for the life of me at the moment see why it isn't faithfully doing what Huang said he had to do, carrying out this review of the facts to see whether they're prejudiced sufficiently to amount to disproportionate violation of 8. Well, what is 55 except doing what Huang told them to do?
My Lord, what paragraph 55 is looking at the facts through the filter of an approach which is focusing upon the question, is this one of the small minority of cases?
Where do we see that in 55?
It's not in 55. The starting point of this is in 46.
Two-thirds of the way down, 55. So they are looking at the quality of family life. They're saying at the present time the parent was enjoying family life with his family. Sufficient quality is to engage on the board. It's not without any family life. They all need receiving support, comfort, and so on.
My lords, what is essentially occurring in paragraph 55, if one leaves aside for one moment the point about delay, is for about a third of the way down, the tribunal is recognizing, it says, refusal of interference means he'll not at present be able to join his wife in the UK. He doesn't have any legal status in Ethiopia. The consequence of which may be that he and the sponsor are not able to, at present, to enjoy family life by being together on any permanent basis. On the other hand, the circumstance happening is whether the sponsor was able to travel, yes, but she hadn't been able to get to Ethiopia for reasons which she'd explained for some time, because she was concerned about the other members of the family being, other children being dispersed and spread about the world.
Well, we can read all of that on ourselves, but paragraph 54 at the bottom of page 106, the very last line, they're picking up exactly what Lord Bingham said the test was, and they say that is the ultimate question that needs to be answered. So that's the standard they set for themselves.
Well, I understand that, my lord, but they look at that question on the basis of the filter that they've already set for themselves in 56, and they come back at the start of their discussion, and they come back to that filter at the end of their discussion in 56.
Well, I mean, there it is. Either we accept you're right in your submission that in 46, 47 and 56, they, contrary to what's said in Huang, they set themselves the wrong test of asking basically whether it's exceptional, whether it falls into the small minority, and that's their approach, or whether they did it as Huang said. I mean, that's the issue.
That's the issue,
well, thank you.
My lords.
Yeah. Really. I think we've got pretty clearly. So, as you explained, I mean, you've got your argument on construction, and this is only if we were against you on that.
Indeed.
If you're in favour of you on this point, what do we do? Again, that's another reason we say for allowing the appeal, is it? As you say, the facts are sufficiently compelling to reach the conclusion contrary to what we see set out by the tribunal on this page.
Indeed, my lord, and I accept that the tribunal here have said that there is some family life being enjoyed through these telephone calls and so on, but that's not the question. The question really is, how is this, the family life that is sought to be protected here is the fact that they want to be together, as any husband and wife would. And Rule 281 and Article 8 in this context is intended to promote that, unless there are interests, state interests, which fall within Article 8 too.
Ultimately, the point turns on the point you've already made, that they misdirect themselves by looking at that issue in the wrong way. Now, if
Indeed. Well, my lord, so be it. The second part of the submission in relation to the Article 8 argument was the point about delay. And what in paragraph 55 the tribunal said is, 5 to 6 lines down, the respondent's delay is a relevant factor. And certainly it is a relevant factor, but really what has to be weighed in the scales when proportionality is concerned is that it is a factor which was a very important factor in this case, not simply a relevant factor. The tribunals rarely diminished its importance. This was a case in which the application had been made in 2003. There's 2.5 years of unexplained delay in dealing with the application. We're now 6 years further down the line. There's a limit to the span of human life, and this man is an aged man. And it really is for the tribunal simply to say it's a relevant factor and then say, because there's a certain amount of family life through telephone calls, that therefore there is going to be no breach of family life if we continue to leave them apart. It is ultimately a perverse conclusion. When one looks at the way in which the immigration judge looked at it, at page 116, he looks at all this family split apart through the war in the Horn of Africa, who have been split through no choice of their own.
So paragraph 2, is it the page?
Paragraph 2, 116, makes this point. And no explanation for the delay provided at all. It is not necessary to fit the arguments about delay into EB Kosovo, because EB Kosovo was in fact a removal case. And in that context, in EB Kosovo, Lord Bingham talked about the sort of circumstances in which delay could be relevant in enhancing people's expectation that they will be allowed to stay and so on. But just as delay in a removal context could be relevant to the proportionality of the Article 8 decision, so also, by the same token, delay in dealing with an entry clearance decision, especially one with this set of facts, can also be relevant when the delay is actually preventing the state satisfying the positive obligation that it has to enable families to be brought together. And whilst the immigration judge appeared to recognize that this was a very serious matter in paragraph 2, but didn't go on to deal with make a final decision on Article 8, although in paragraph 23 on page 121, it's quite clear that he thought this was an extremely strong Article 8 case, top of page 121, strong compassionate factors, strong Article 8 grounds. The tribunal simply say delay is just a relevant factor. They minimize it in that way. They simply say, well, there's telephone contact between them. There's some family life. And therefore, bearing in mind, in effect, the rules rule out third-party support, and that is where the line is drawn. So also, in relation to Article 8, it must be the case that on those considerations, the Article 8 proportionality balance has to be drawn against the appellant. And we say that's just downright perverse. On facts which are as graphic as this, what could be more perverse than to say to a man who has had his family split apart in this sort of way, where the mother has had the children separated in this way, who now is trying to bring the family together after some period of time, to say that continue your family life through telephone calls.
Well, I don't think you need to elaborate that point. I'm concerned about time now because you bid for 3.5 hours.
My Lord, I hadn't intended the afternoon session to actually be this long, and that's my fault, I'm sure. Those essentially are the points in relation to the Article 8 claim. The other points on Article 8 are set out in the printed case, particularly in paragraph, the summary in paragraph 31.
Yes. This is on issue 3. you set out a summary of pages 16, 17 and 18.
That's right. And the last point on that is dealing with AM's case. And Mr. Collins invites me to remind you that in the VS case, Lord Justice Sedley, in giving permission, did make this point again at page 42, that it is not going to be at paragraphs 8 and 9 that the significance of AG Eritrea needs to be appreciated, and tribunals can't just shrug this off as saying they're going to continue business as usual by saying nothing's changed, notwithstanding the House of Lords decision in Huang. And that's really what comes through. And that was Mr. Justice Hodge again. Because you can get a flavour of Mr. Justice Hodge's approach by paragraph 42, page 7, where in that case, in VS, Mr. Justice Hodge said, although the concept of a legal test of exceptionality has been rejected, the approach to article cases will be as before. It's not as before. There's a significant change which actually carries through into actual findings and actual end results. My Lords, I'm conscious of the Court's indications, and the submissions are set out in writing, so those are my submissions.
My Lord, not proposed.
Lords, I'm here for Mr. Drabble.
SA and AW being dependent on SA, as I understand it, and we've got AM2.
That's right, which has a distinct point about Article 14. So SA and AW are Rule 281 cases. It's the same error of law, and in these cases it would be a remittal. You see that in the Statement of Facts and Issues, paragraphs 3 and 4. I'm going to make some brief submissions about the question of interpretation, and they'll of course be adopted in the other case, AM number 2, where the same point arises. We reserved it in the Court of Appeal. The nub of the matter, we suggest, is in the phrase in the rule, read as a whole, and in particular by reference to the words without recourse to public funds. And if I can start just by giving you one reference, it's to the printed case in AM number 2, where the point is picked up at paragraphs 5 to 7.
Paragraph what?
Paragraphs 5 to 7 in the appellant's case in AM number 2.
Page 4?
Page 3.
Oh, it starts at page 3.
Yes, and on over the page at page 4. And that's the answer. While we've got it, the answer in relation to the child rule, we respectfully submit.
Sorry, this is the point, is it, on the phrase being OTAs, if they're right?
Well, it's that without recourse to public funds is telling you what you can't do, but what you can do is have recourse to private funds. And yes, one of the consequences is that were it otherwise, if maintain themselves already meant that it had to be internal to what you've already got from your own resources, it would be very odd for the phrase to go on to say, without recourse to public funds. Yes, yes. Now, there's no problem in relation to the first phrase, where whoever's doing the maintaining, you always need a phrase in the rule. There's no tautology in having the maintenance provision. If you deleted those words, the rule wouldn't make any sense. But there is a real problem with the phrase without recourse to public funds if you've already got there. While I've got this document, can I just also show you, because it summarises, I hope, helpfully to the court, at page 5, what we would respectfully suggest is the answer to the MW case and the child rule. It's paragraph 12, and then on over the page, 13 and 14, and it's the distinction between a who question and a how question. The fact that the responsibility for the child, including maintenance, may, under the rule, for good reason, need to be the parent, whom, after all, they are seeking to join. That's the purpose of the entry clearance. Doesn't tell you that when that person discharges that responsibility, that they must only do it by reference to resources which they already have.
Well, are you really addressing the little 3 problem in the child case?
Yes, I'm going to come back to that rule.
So, I mean, the tense is different.
Yes, yes. I'm dealing with the phrase which led the Court of Appeal.
Which rule are we at?
I'm discussing at paragraph 12, rule 297.
Yes, there isn't a little
There's
3.
3 there.
Yes, you there.
No,
No.
no.
And I'm addressing there the use of the phrase by the parent. I'll come to it because I'm going to go back to the rule. I'm just setting the scene.
The reason that it isn't there is that by definition, I suppose, a child is dependent on its parents.
Right, yes, we'll come back to it briefly, if I may. But can I start with the statute? You saw the 1971 Act, you'll recall it, and Section 3. In particular, it's in the first bundle of authorities, and it was at tab 2. And as the court will recall, this is a statutory provision in primary legislation which enables the decision maker giving leave to enter or remain. It's at the bottom of 1563 in tab 2 of bundle 1. If he's given limited leave to enter or remain in the United Kingdom, it may be given subject to all or any of the following conditions, and then Roman 2 is a condition requiring him to maintain and accommodate himself and any dependents of his without recourse to public funds. So take that as an example. Suppose a grant of limited leave to enter or remain, where the condition is formulated in that way. The critical thing that we submit is not to stop at the word himself or the words of his, but to read the phrase straightforwardly as a whole. Maintain and accommodate himself and his dependents without recourse to public funds. Take an example. Suppose someone who is employed and loses their job, and they're here under a condition of limited leave to enter or remain. They need to tide themselves over until they're able to get the next job. If they can do that by getting a loan, perhaps from a bank, perhaps from a family member, perhaps from a friend, are they in breach of the condition of their leave to remain? And we submit on a sensible and straightforward reading, they would be maintaining and accommodating themselves without recourse to public funds.
It's the same point.
It's the same point. And it would be very odd, we suggest, if the answer were otherwise, not least because there would be criminal implications and implications for the individual being unlawfully here within the United Kingdom. We also suggest that it is revealing, and we don't need to turn it up, but Miss Carsfrisk's printed case in AM number 2, and it's at her paragraph 29, does, we suggest, rather revealingly show that she is the one here who is reading words in to the rules which words aren't present in the rules, because at the end of her paragraph 29, describing the function of Rule 281, he says, the rule requires the parties to the marriage to maintain themselves without reliance on either public funds or the support of third parties. Well, it simply doesn't say that. And as my lords have seen this morning, there are other rules that do say that. It's in AM number 2, my lord. It's in the core volume. It's in the respondent's case. And it's paragraph 29. And the respondent's position is that the rule is requiring the parties maintain themselves without reliance on either public funds, and then these words. While we've got that, we would suggest that it's also revealing that the entry clearance officer, the respondent in these cases, suggests in argument that it is supportive of the promotional purpose of the rules that self-sufficiency, not from the state, but from family and friends, it is being something that's promoted. And we simply submit that that is unsustainable. It's paragraph 31.3, where the respondent says this: paragraph 281 is concerned with enabling a particular family unit to live together. Well, we agree. To require the parties to maintain themselves without reliance on third-party support reinforces that purpose. And we say that simply does not follow that it reinforces the facilitation of a couple being together to stop them being able to satisfy this requirement by reference to friends or family. Indeed, quite the contrary. If the respondent is correct, the implication of being able to maintain themselves without recourse to public funds, but by reference to some other family member or some other individual or source, it has the consequence they can't be together because the entry clearance is refused. So it's not, we submit, a sustainable answer. Can I give you one reference to an authority which I think you haven't yet seen, but illustrates the practical implications of all of this? And it's a tribunal case called Mahmood. It's in the Authorities, Volume 6, and it's at tab 62. And it's a good practical illustration of what the implications are. Mahmood, tab 62 in bundle 6, is a case where there was an uncle, see paragraph 3, about 5 lines in, who was a wealthy businessman owning various pizza shops. And if you look, and I'm not going to take you through it, it wouldn't be a profitable use of time, but I commend it to the court. At paragraph 8, the tribunal is dealing with the evidence, 4 or 5 lines from the end, an affidavit from the uncle and oral evidence from the uncle. The immigration judge had held that support from a third party wasn't permissible, but as the tribunal explains, it's paragraph 12 at the bottom of the page, that point had been dealt with by Mr. Justice Andrew Collins in the High Court in Amal Ali, but in any event was clear from the rule. That's paragraph 13. And then paragraph 15 illustrates the practicalities, because this is a case where the tribunal was able to be quite satisfied that there would be no deficit, no recourse to public funds based on the clear evidence emanating from the wealthy uncle. And then in the end, there's a reference to the judgment that you have seen of Mr. Justice Collins as a clear statement of the law, just halfway down the final page.
What was the uncle going to do? Was he going to provide him with a position on the firm?
The uncle was already providing a monthly allowance to the wife in the United Kingdom. He had made an offer of employment in his businesses for her, which she had taken up, and he had made an offer of employment to the husband who wanted to come here and live with her. And it's a very good illustration of how there is no prejudice to the purpose of the rule protecting the public purse, providing, which is the premise for the argument in any event, providing that the adjudicative decision maker is truly satisfied that there will be no recourse to public funds. We agree with Mr. Gill that the position as to accommodation under our rule, we're concerned, of course, primarily with the spouse provision, Rule 281, is revealing. As to accommodation, as the court knows, we had it in the rules at page 2933, and it's Roman 4. It is well established that accommodation can be supplied by a third party. The rule itself is clear that providing you occupy the accommodation as a couple, you don't have to own it. Indeed, you could do it at a cut price rent, or indeed rent-free. The pizza uncle could have provided the accommodation to the couple with no payment of rent at all. Not only is that established at the level of the tribunal, but Lord Justice Laws in the judgment below expressly accepted this point. You find it at paragraphs 45 and 61. But it gives rise to a very curious position if the respondent is right in the arguments that were accepted below. What it means is that in relation to maintenance, the couple has to be economically self-sufficient of everybody, but in relation to accommodation, including the cost of accommodation, they don't.
Well, Lord Justice Laws at 61 says that doesn't follow. He doesn't see any problems there.
Well, we submit that it is a logical problem. If the purpose of this rule were to secure that the couple can stand on their own 2 feet with no financial assistance from a family member, then why would the rule permit, as the tribunal cases show that it does, why would the rule permit accommodation to be supplied rent-free by a family member? There's also the problem we respectfully submit in relation to the idea of precariousness.
Idea of what?
Precarious arrangements.
Precarious.
If the arrangement for the accommodation can be with a family member, and in fact you can live in a room, as you've been shown in the cases of a house owned by a family member, and if that doesn't have an inherent precariousness rendering it inadmissible for the purpose of this rule, well, why should it be any different when the arrangement relates not to waiving rent every month, but providing a cheque every month?
Lord Justice Laws, that's saw the accommodation point in terms of suggesting what very wrongly, but he doesn't mention rent-free or waiving rent. He doesn't penetrate the accommodation point as far as that. Accepts the point in general terms, but I see, of course, what you're saying.
Well, my submission...
You can do it by saying, all right, let's waive the rent because you've got already and you can stay there rent-free.
Yes.
That really isn't very far away from what
Not in substance at all, and impossible in terms of purpose. My lords,
Has anybody else, you put it in terms of waiving rent or anything of that kind? It seems to be accepted as true that you can rely on accommodation by others, but does it actually...
I'm not owning a novel point here. The cases relate to people who live in rooms of family members through the generosity of those relatives. You don't get to waiving a rent because you're not paying in the first place. But in principle, it must then follow that the arrangement could be made with a family member or with a friend to say, I will provide you this accommodation. And it will either be at a payment of cut price rent or
I
no.
mean, it would have to be a sufficiently solid arrangement that the family member couldn't say, goodness, I'm fed up with you, off you go. Because otherwise it wouldn't work. And it's got to be exclusive occupation of adequate accommodation. So presumably, I mean, you've got to have your own bathroom, haven't you? I don't know. I don't think it could apply, could it, to a shared bathroom?
Yes, it has applied, and it's reflected in the Secretary of State's own guidance to entry clearance officers. It has applied to a room, and ironically, part of the rationale for that is because this recognises what families do for each other. They provide accommodation for each other. But my answer to my Lord Brown's question is that as to whether one needs something substantive and concrete is, of course, because one needs here to be able to satisfy the decision maker that there will be, not my words, the words of the rule, adequate accommodation without recourse to public funds.
This presumably can be supported by a request under Rule 35 for an undertaking.
Yes, it could be, yes.
Which shows the kind of thing one's dealing with here. This is an undertaking which is sufficiently serious to lead to a prosecution of this breach.
Well, take the case of the uncle who provides the house. He's not the sponsor.
No, he couldn't give an undertaking.
He's not the sponsor. And again, it makes my point that the purpose and structure and wording of the rule makes sense on our interpretation, but unravel once it's recognised that accommodation can be provided in that way. Were it essential to have enforceable undertakings under Rule 35 from the provider, then you'd need it for the provider of the accommodation. And it's not required in the rule. Indeed, the point goes a little further because, as you'll have seen from the authorities, this logic, the logic of the argument that says the who question, who is providing or maintaining themselves, also carries with it the how question, are they doing it from their own internal resources? The logic of that carries through to other immigration rules that don't have sponsors. Because the argument has been put by the entry clearance officers and upheld by the courts that if you are being required to maintain yourselves, and if that means maintain yourselves from your own internal resources, well then the sponsor really is neither here nor there. And I'll give you an example of that in a moment. But if it's right, And it certainly reflects the straightforward wording of the rule as well as the cases decided under it, that the accommodation can be in property owned by someone else, indeed even sharing a property owned by someone else, then for the reasons I've endeavoured to give, it cannot be fatal or determinative or drive the interpretation of the next provision to say, well, obviously, resources have to be from someone who's given an undertaking. Why so when it's not so in relation to accommodation? But my Lord Brown's question leads to the answer that the decision maker must be satisfied that it will be provided without recourse to public funds. Now, whether it's an affidavit or oral evidence or something else that the provider puts forward so that the decision maker is satisfied, they must be. Can I then, as I promised I would, return very briefly to the child provision and its Rule 297. And I do so because although there is no child case before the court, the problem in the line of authorities arose because of this provision. And what Lord Justice Laws concluded in the judgment below in this case was that really the issue had been decided by the Court of Appeal in MW in the interpretation of 297. We submit, and I've shown you where it is in the second of the two printed cases, we submit as follows. Firstly, it's important to see that the premise for 297 is that you've got a child who needs to be with the parent in the United Kingdom. See 297, particularly Roman 1, D, E and F. Those are the circumstances that need to apply. It's your only parent. It's the parent with sole responsibility for you. Or it's the parent or relative and there are serious and compelling family or other considerations which make exclusion undesirable. So the starting point is that you have to need to be in the United Kingdom with the parent or relative. Secondly, it's also the premise that it's a child, so you're under the age of 18, and you're not living an independent life. That's 297 at Roman 3. What then follows from that is that you can receive entry clearance to join the parent or relative being accommodated by the parent or relative that you are seeking to join in accommodation which they own or occupy exclusively, and that you will be maintained and maintained adequately by that parent or relative that you're seeking to join, all of which has to happen without recourse to public funds. So it has to be a situation where you are joining your parent or relative to live together, be accommodated with them, be maintained by them, but none of that compels the answer that in accommodating you or in maintaining you, they can't look for help if they need help. On the contrary, the thing that they're not allowed to do is to have recourse to public funds. We would respectfully submit that the concerning conclusion that the Court of Appeal reached in MW was therefore, with respect, unsound. True, the rule specifically says by the parent in 4 and in 5, but that does have a child protection aspect to it. It means that the rule is ensuring that the child not living an independent life under the age of 18 needs to be with the parent, and the relative will indeed be with the parent or relative. It won't be cast adrift or being dealt with, provided for in some other way. Now that is entirely in step with what the Court of Appeal had previously said about this rule in the case of M&A, which you saw. We don't need to turn back to it. The relevant paragraphs, though, are paragraphs 23 and 26 in M&A law. Justice Dyson and Lady Justice Hale, as she then was, respectively, emphasising the purpose.
And they could have amended it, instead of saying by the parent, say with the parent. That might have made your argument even stronger, mightn't it?
They could, certainly.
Wouldn't you be better off if they had?
I submit that it doesn't matter, because what the rule is requiring is parental responsibility. And what by the parent connotes is that the parent has the responsibility for the accommodation and for the maintenance. M&A, which supports this approach, you saw it, we don't need to turn back to it. It was Bundle 5, tab 42, and it was paragraphs 23 and 26.
Do you say the child has to live with the parent? Supposing the parent has got 2 flats or something like that, and one of them, where he or she lives, is very full, but next door she's got another. He or she's got another one she owns. He or she owns. And the child's 16 or something like that. So they say, well, that child can go in there. Would that be? I mean, that would still fit, wouldn't it?
The rule. Well, to be fair, I have to accept that the rule says accommodated in accommodation which the parents or relative the child is seeking to join, own or occupy.
Oh, yes. Oh.
So you do have to be together.
Why?
Sorry, why do you?
Why do you?
So why do you?
I mean, the parent would own the accommodation, and the child would be in it. It's provided by the parent. Next door, or whatever it is.
Yes, I see. My answer holds for occupy.
Yes,
but my lord is right, entirely right for own. Either way, it supports me in relation to buy, because buy is responsibility and provision. It doesn't tell you how the parent has to undertake that responsibility or make that provision, except that it says what the parent can't do.
Your submission is completely consistent with the structure of 281, 297 and 317. If you ask in 281, where you have spouses, who maintains them, the answer is themselves, of course. If you ask in 317, where it's a parent or grandparent, presumably on their own, they just have to be maintained. You don't ask who maintains them.
Yes.
And then with a child in 297, who's the natural person to maintain a child? Parents.
Right. And it's all the question of who. Yeah. With the spouses, the question of who relates to living together with your spouse and looking after each other. But when you ask the question not of who, but of how is the maintenance to be done, how is the accommodation to be done, the rule gives you the answer. Without recourse to public funds. I'm sorry, my lord.
If you've got 1 or 2 points to add, it's just about one time now. Would you like to break off here, or would you?
May I make one final point in this regard,
Yes.
without needing to turn anything else off? If you had a private school and some rule or arrangement required that the parent take responsibility for schooling the child, you're not going to let somebody come off the street or somebody say, I'm an uncle, or for that matter, be an uncle. If you live with your parent, the parent must take responsibility for providing the education of the child that would have good child protection purposes behind it. But it wouldn't begin to tell you that the parent, in taking responsibility and enrolling the child, isn't allowed to draw upon money from a family member that helps them to be able to discharge that responsibility. And we say that is the sort of sense that one can see. And it doesn't lead to linguistic differences between rules. It works in relation to the immigration rules consistently, where this important phrase coming from the primary legislation is to be found. Well, can I leave it there until tomorrow?
Yes, indeed. Well, we will see you again tomorrow morning at 10:30.
Thank you, Mother.